Hello, everyone, and thank you for attending today's Venable webinar, Contract Performance and Frustration in Coronavirus's New Normal, Performing the Impossible and Impractical in Key Jurisdictions. This is Christopher O'Brien. I'm a partner in Venable's Los Angeles office in the Corporate and Transactional section. A couple of housekeeping things. The recording and corresponding PowerPoint slides will be available for download later this week. We'll send out items for CLE or MCLE credit later this week. If you have questions during the webcast, there's a widget on the screen that's showing the slides, and you'll be able to send those in, and we're hoping to have some time towards the end to go through questions that people might have. First, I'd like to introduce the other folks who are going to be presenting today. We've got Jennifer Bruton, who's a partner in our Washington, D.C. office and the managing partner in charge of that office. She's a real estate partner. Ed O'Toole is one of our partners in litigation in the New York office. Ben Whitwell is also a partner in Los Angeles in the litigation section. And Melissa McLaughlin is a counsel in the litigation section in Los Angeles. The goal for today's presentation is to provide a framework to analyze how the COVID-19 pandemic might affect contract performance, especially where agreements are silent and common law principles will apply. The first thing I'd like to do actually is start off with a quote that maybe can serve as a bit of a coda or a theme for us. There's a movie that for some reason I was put in mind of last week called Starman, starring Jeff Bridges from many decades ago in the 80s. And it's a movie about a space alien played by Jeff Bridges who comes to the world, takes the form of a human being, goes through a series of adventures and misadventures, and towards the end of the movie, he's speaking to an actual human being about human beings, about the human race. And he says, and I'm quoting here, "You are a strange species, not like any other, and you'd be surprised at how many there are. Intelligent but savage. Shall I tell you what I find beautiful about you? You're at your very best when things are worst." Maybe that's a bit of a meta theme for us as we talk about contract performance or non-performance in this environment. The roadmap for today is also sort of how I think about analyzing contracts in this environment if I put on my general counsel hat. The first thing is which state law applies. I guess the very first thing is I figure out which side of the contract I'm on. But which state law applies? As everyone knows, contract law in the United States is largely a question of state law. Then there's a major branch in the analysis, which is, does the contract address force majeure events? If it does, then the exercise is largely going to be to construe the language and the intent of the parties through whatever evidence is admissible. For example, in the M&A context, it's almost always the case that there's a MAC, or material adverse change, or an MAE, material adverse event or effect provision that governs if the parties are going to need to, or if the buyer can get out of closing between signing and closing because of an adverse event. We're really not going to go down that path very much today because that's going to be a question of construing the actual language of the contract. And by the way, just parenthetically, in the M&A context, you're going to find that a lot of those MAC clauses don't apply when it's a general effect on an entire industry or a country. I think we'll see those things reconsidered in the future based on COVID-19. The second branch, the one we're really going to speak most about today, is if the contract does not address force majeure events head on, then common law principles of impracticality or impracticability, impossibility, and frustration may apply. that's where the meat of the presentation is going to be. There will be mixed cases where there is some mention of force majeure in a contract, but it doesn't clearly apply to the performance at issue. And those are interesting cases. We've seen some of those. And I think one of the arguments you'll see put forth is, well, if the parties mentioned it in one section of the contract and not in another, they specifically meant for it not to apply to the performance at issue, and it shouldn't. Of course, where you sit on that depends on which side of the contract you're on. Going down the analysis, is this a force majeure event under the contract? And the litigators on the phone can address that question. And crucially, if there is a force majeure event, what is the effect? Is the contract simply terminated, or is a party excused from their performance? Particularly if the other side has already given the benefit of the bargain, can a judge or arbitrator fashion other relief, such as rescission or some kind of relief for the party that did perform? And lastly, as I said, we'll have a Q&A section at the end. If you have questions, we can hopefully address some of those, although we will try to end on time. As a sidebar, I wanted to say, as a transactional lawyer, for contracts that are currently under negotiation or being drafted, and that is continuing to happen in this environment, I think it's crucial, and you must consider addressing COVID-19 and its downstream effects in your contracts now. You'll see that one of the elements that is considered by courts is this an unforeseen event? Nobody can say that COVID-19 is an unforeseen event anymore. And I think you need to specifically address secondary effects that could delay or excuse performance. So with that, I will turn the presentation over to Melissa McLaughlin to talk about general principles of contract law.
Thank you, Chris. Let's go on to the next slide while I get started. So I'm going to start with just some general force majeure principles, and then we're going to move on for most of the rest of this webinar to the common law doctrines. But it's good to have these in mind as we're going through everything. A contract that has a force majeure clause allows the parties to decide ahead of time when contract performance will be excused. And it really gives the parties a lot of control. You can determine what events will excuse performance, whether all or just certain kinds of performance will be excused, whether a force majeure event cancels the contract or just delays a party's performance, and what kind of notice is required to invoke that clause. Then if a force majeure clause is being invoked, it's going to act as an affirmative defense. One sort of obvious point, but we should mention it, is the force majeure event that a party is relying on for non-performance can't be caused by the party. It has to be an event that's actually beyond the party's control. The force majeure event needs to fit within one of the categories in the clause, which Chris has alluded to. And under the circumstances we're in now, we can think about what category this event might fit into, even if the most obvious category, such as epidemic or pandemic, is not listed. So, for example, if one of the force majeure categories is government action, and there's a stay-at-home order or quarantine order that prevents performance, you may be using that category rather than the more obvious pandemic category. And some contracts will also have a catch-all clause in their force majeure provision, and that would expand the possibilities there. And then finally, the contract is going to set forth any additional requirements, such as notice, that the non-performing party needs to meet in order to invoke force majeure. Next slide, please. So moving on to the common law doctrines, impossibility, impracticability, and frustration. These doctrines, any of them could apply to excuse performance, even if the contract doesn't have a force majeure clause. The doctrine of impossibility has largely shifted in jurisdictions to impracticability, recognizing that actual impossibility is not a requirement, just that the performance has to be highly impracticable. The frustration doctrine is alternately called frustration of purpose or commercial frustration, and that's pretty similar to impracticability, but it has one key difference that we'll get to in a little bit. And often you'll see a party trying to invoke both frustration and impracticability at the same time. Now, it seems like it would be unfair to have one party performing and the other party not performing because of one of these common law doctrines. But we should keep in mind that relief is potentially available, for example, restitution for the party that performed. And my last background note on these common law doctrines is they are not very often successful. They're probably invoked more often, and you wouldn't see a party win on any of these so much, but we all know the circumstances that we're in right now are pretty unique, and so we'll see what courts have to say when some of these issues actually come up in real time. Next slide, please. The restatement of contracts, which is important because it sort of sets forth the basic elements of the doctrines, and many jurisdictions follow the restatement. This gives the requirements for practicability and frustration. And the two doctrines under the restatement share three main principles. The parties assumed that this event would not occur. There's no fault by the non-performing party, and the non-performing party's duty to perform is excused unless the contract language or circumstances indicate otherwise. Now, the main principle where these two differ is under the impracticability doctrine, there's an event that occurs that makes a party's performance impracticable, while under the frustration doctrine, the event that occurs substantially frustrates a principal purpose of the contract. Next slide. So the first jurisdiction we're going to start with is Delaware. And Delaware is an important jurisdiction to consider because a lot of companies being organized or incorporated in Delaware or having a Delaware choice of law clause in their contract or the internal affairs doctrine, all of those can make Delaware law apply even if the actual contract performance or the parties are located in another state. So in Delaware, they follow restatement, and their elements of impracticability are as follows. An event occurs that the parties assumed wouldn't happen. It's not commercially practicable to perform, and the not commercially practicable can encompass either extreme and unreasonable difficulty, expense, injury, or loss to a party, but it does not require impossibility. And finally, the non-performing party didn't expressly or impliedly agree to perform in spite of the impracticability. Next slide, please. And Delaware's frustration doctrine, also following the restatement, is similar. Requires that there's a substantial frustration of a principal purpose of the contract. The parties assumed that the event causing the frustration wouldn't occur, and the non-performing party is not at fault. So a few things that we can think about when these doctrines come up in the context of COVID-19 are whether the event is actually unforeseen. Most of us didn't expect a pandemic or our state governments or local governments to order the closure of businesses and stay-at-home orders. But if you're dealing with a contract that was entered very recently and the parties knew what was going on in China and Italy, then you may have an argument that this was not unforeseen. Another thing we can think about is whether performance is truly impracticable or not. Some of the orders that we're under might allow for more work and more movement than people would initially assume. And so we can think about whether a particular industry fits into an exception to a stay-at-home order, or whether performance could be accomplished by working from home. And one thing that comes up sometimes in these impracticability cases is the performance is not necessarily impracticable just because it becomes more expensive. So a slight additional expense to performance is not going to garner a lot of sympathy with the court, but like I said before, and as we all know, these are very different circumstances that we're in right now, and we'll see how all of this plays out in courts. The added expense might be large enough to move into impracticability when in past cases it might not have. And with that, I'm going to turn things over to my colleague, Ben Whitwell, a litigation partner in our Los Angeles office. He's going to talk about California.
Thank you, Melissa. If we could please move to the next slide. What you're going to see is that the requirements for both impracticability and frustration in California are very similar to the requirements in Delaware and the requirements under the Restatement. Traditionally, California followed the doctrine of impossibility, but the current doctrine is impracticability. And a thing is impossible in legal contemplation when it is not practicable. I know that sounds somewhat circular, and it may even be somewhat circular. But a thing is impracticable when it can only be done at an excessive and unreasonable cost. So to some extent, the California law does focus on cost, because there are so many things which in fact can be done if you have an unlimited budget and you can just, completely change the way you go about doing it. But nevertheless, impracticability does not require literal impossibility. Please go to the next slide. California frustration doctrine, it assumes the performance is still possible. That, as Melissa mentioned with respect to the Restatement in Delaware, is one of the key differences between frustration and impracticability. It requires an unanticipated supervening circumstance, which is it throughout the states. Purpose of contract is frustrated by the supervening circumstance, and that can be a somewhat subjective discussion, but it really goes to what was the core of the contract, and is it frustrated by the circumstance? And the value of the contract has been destroyed by the supervening circumstances. So since we have all of these similar doctrines, I think it's important to consider, what they really are. And what I believe is that these doctrines are flexible doctrines that effectively allow the courts to do equity in a very unusual circumstance like COVID-19. And we're already seeing courts making much more of an effort than even they normally would to do equity. And as a result of that, if you want to be successful right now in court, I believe that you need to be more focused on, are you being equitable than you even normally would? It's important to be in there saying things that sound like you're trying to be reasonable, that you're not just trying to avoid an obligation, that you've made every effort to find a way to perform, but that you really are blocked from being able to do so. And it's also important that you not waste the court's time. There's been some very amusing examples of recent decisions from the courts where litigants just got trashed for bringing something before the court that the court thought was just not sufficiently important to be taking up court time given all the problems we have right now. Now, what are you going to base your impracticability defense on? quite possibly you're going to be basing it on a government order, a government lockdown order. I would urge you to strongly read all of the fine print of the orders. Most of those orders are being presented in the media as much broader than they actually are when you read the fine print. There are a lot of exclusions and a lot of exceptions. I would also suggest that you look closely at other forms of governmental action. I mean, for instance, here in Los Angeles, Film LA has pulled all the location permits. So even though you might be able to otherwise, have your production, you can't do it because you can't get a location permit. School closures. Schools are actually allowed under the California lockdown order to be open, but most have chosen, and maybe all, to be closed. So that's, something that's still a governmental action. Unions can get involved, and union directives can be almost considered a form of governmental action. And as of today, you have the president and the lieutenant governor of Texas essentially calling for, a return to normalcy. Let's all get back to work. I think that what you're going to see over the next few weeks is even more of a patchwork of government regulations in different locales. So if, using production, because I do a lot in that area, if you were going to shoot a television commercial in Los Angeles and all of a sudden Texas is saying, hey, we have all sorts of production facilities and we're open for business. Is it still impracticable? You have to consider those things. And you also have to understand that just because you can't do something in the way that you would normally do it, doesn't mean necessarily that it's impossible or impracticable for purpose of advancing one of those defenses. This is not the purpose of this webinar, but look carefully at all your insurance policies, whether that's business interruption insurance, key person insurance. The insurance policies in place have provisions that might get you some coverage. Also, be careful about new insurance policies that are being issued. I can tell you right now that the insurance companies are rewriting those exclusions, as we speak, and are making them broader. Now, before you rush off to court, I would also urge you to be very thoughtful in terms of trying to find ways to solve your problem without the court. That could be mediation. It could be binding mediation. If you could partially perform, you're going to look much better in court if you've partially performed rather than just walking away from the whole thing in its entirety. Again, this is going to be a situation where it is very difficult to solve the problem by going to court. Most emergency relief, at least in this area in Los Angeles, is almost unavailable except for true emergencies, and many commercial situations will not be considered true emergencies. So as a practical matter, even if you intend to litigate, you're probably going to have to come up with a solution on your own in the interim. Now, what happens if you have a client who has a weak argument under frustration or impracticability? I would say that's okay. Please keep in mind that this is only a breach of contract. It may be that your client needs to breach, even if it knows it will likely lose on its frustration or impracticability defense. There's no punitive damages for a breach of contract. If it was for a sum certain, there is high interest in California of 10%. It's possible that somebody could get a writ of attachment. But all of that economic analysis is something that sometimes lawyers shy away from, and they don't like to proceed if they don't feel they have a good legal argument. But once you've looked at your contract's provisions for venue, whether there's an attorney's fees provision is a huge one to look at. What the choice of law is there an arbitration provision? If you come to the conclusion that, or your client comes to the conclusion that you are going to not perform, regardless of whether you have a strong defense, that actually gives you leverage. There are many situations in which when you make it clear to the other side that no matter how much they beat their chest about the fact that you have to perform, if you say, I'm sorry, we're not going to, all of a sudden they're more willing to talk about commercial resolutions. And commercial resolutions are going to solve the vast majority of these problems with court, even more than it usually is, I believe, as a last resort. So with that, I will pass it to Jennifer Bruton.
Thanks, Ben. So here I'm going to talk about real estate agreements. And there are, go to the next slide, please. I'm going to focus on leases, but I do want to touch on the three major types of real estate agreements that folks are used to seeing in commercial context. The first being purchase and sale agreements. And I know we're focusing on what the common law rules are, and you'll see they're pretty consistent across the jurisdictions. But for purchase and sale agreements, which are usually of the shortest duration of contracts, of real estate contracts compared to loan documents and leases, a lot of this is going to fall to drafting. If the contract's already out there, consider obviously exercising your rights during feasibility. Consider provisions that might, and you'll consider these provisions in drafting. If you haven't yet executed a contract, typical purchase and sale contract addresses casualty and condemnation, but often doesn't have any other contingency that would be triggered by an event like this, as opposed to, a tenant still being in place and things like that that are very deal specific. What you're going to want to look at is your feasibility period, maybe a protracted one in this instance. The definition of what a business day, there's often a provision of what a business day means. There's often a provision in a purchase contract that provides that in the event that the performance of any obligation falls on a day that's not a business day, it pushes to the next day. And we're seeing now people changing that provision to a business day is a day on which there's no sort of state of emergency or otherwise government prohibition, and you have to define that because it depends on whether it's state or local, state or federal, and there's a lot of nuance if you're an essential business. But then also having the closing, for instance, being pushed till X days after all this ends, and then considering outside dates for performance, so that people are not bound by a contract for longer than they thought they would be. And of course, we hope this is all very temporary. And then in loan documents, usually those are built with a kind of you'll pay the lender hell or high water situation. And the irony is that, in fact, loan documents, while they don't give borrowers any relief for force majeure, they may in fact trigger default if they have provisions in them. My colleagues mentioned material adverse change, material adverse effect. There's some bank loan documents have general insecurity provisions in them, and those might trigger problems there. Might trigger lender rights just because this is happening. But focusing on leases almost always in commercial context address force majeure and provide, and you'll see this, that force majeure might offer you an excuse for performance for non-monetary obligations, such as a covenant of continuous occupancy or operation in a retail lease, but expressly do not afford any relief for payment of rent. They usually say that it doesn't excuse payment of rent, and financial hardship is not an instance of force majeure. So then if we go on to the next slide, which I've touched on force majeure, you're going to see in contract provisions, you're going to see address of eminent domain and other governmental action in these contracts. Sometimes, depending on the contract language, you could argue that this is a governmental action that if it's not defined as a taking, they're not actually taking the property for public benefit, which they're not. And then the same principles that we're all discussing here apply. Frustration of purpose, impracticability, impossibility, and then ultimately you have to, as Ben mentioned, equity. You have to think about what's fair. I'll circle back around on this, but these are situations where if you're the landlord or you're the tenant, neither of you's done anything wrong. If you're the borrower or the lender, nobody's done anything wrong, but we're in a situation here, so we need to figure out the fairest and most right way to solve the problem so that everybody survives the X number of months of this shutdown and then can continue on and do business. Can we go to the next slide, please? Much like the restatement of contracts, the restatement of property provides guidance in these instances, and we thought the points most relevant here were the tenants on government action and illegal use. And so the restatement suggests that a tenant may terminate the lease if the use of the lease property was intended by the property, the use which was intended rather, is frustrated by government action apart from the taking by eminent domain, if the action was not reasonably foreseeable by the tenant at the time the lease was made. Now, as we've touched on, if your lease is already existing, this surely was not reasonably foreseeable. But I am in the middle of negotiating several leases where we're talking about delays during a build-out process, and if your contract hasn't been executed right now it's very foreseeable, and I don't think a general non-specific language that you would normally see in a lease agreement will address this if you don't address it head-on. And under the Restatement Second of Property, it says that the doctrine notes that the doctrine is applied sparingly, which we've said. This is not a slam dunk. The burdens, the continuation of the burdens of the lease have to impose extreme hardship on the tenant. The intended use has to be frustrated, and real estate is unique because it can be used for many things. So just because it can't be used for the thing that you want to use it for doesn't mean it can't be used at all. This comes up in the instance where a lot of people are wondering if, well, you can't really use the space, so can we not pay rent? But you still probably have a skeletal crew there. You have all of your things there. You haven't removed them, such that the landlord could use them for somebody else. And also, you find even retail uses are trying to, at this point, think of ways to pivot and serve takeout from a restaurant, but not seating, to fulfill online orders from the store so as to keep down traffic. So there's other uses. For the restatement, if there's an illegal use, if the intended use by the property becomes illegal after the lease is made without the tenant's fault, and no other use is permitted or would be unreasonable to place upon the tenant the burden of converting to a different use, then there may be a remedy. But this would only come into play when the lease restricted the tenant to a very specific use that was no longer legal after a change in law. And here again, we're hoping that this is temporary, so it's not permanent enough often to terminate a long-term lease. These leases are for 10, 15 years, and we're hoping this is a matter of months. You can go to the next slide, please. Examples in Maryland of frustration in commercial leases. There's Montauk versus Seeds. The court held there that in determining commercial frustration, the most important factor for consideration is whether the intervening act was reasonably foreseeable, and then they have to consider whether the exercise was an act of sovereign power and whether the parties were instrumental in bringing it about. And this was a contract case where Seeds had contracted with Montauk to provide certain services for them, and then Montauk later found that the government would provide the services, but it wasn't beyond the control of Montauk, and the holding was there that they were still contractually liable to Seeds, even though they found the government would provide the service for them. So the next point, generally with respect to leases, the doctrine of frustration has been limited to cases of extreme hardship. You have to prove it was reasonably or was not reasonably foreseeable, and that the value of the premises was totally or substantially destroyed. So again, this is really this is a situation in this case in Maryland Trust versus Tulip, where at the time Acme contracted to lease space, they were aware that there was an ongoing dispute with a neighbor, and the result of the neighbor was that the court ordered something that Acme didn't like, but it was reasonably foreseeable at the time. It robbed them of use of certain parking, but they knew when they signed the lease that there was this ongoing dispute, so they couldn't say that it wasn't reasonably foreseeable, even though it was beyond their control. They should have contracted around it. We can go to the next slide, please. In Virginia, this is addressing impossibility within a force majeure clause. And this is an instance here in Reston, an instance in which force majeure did excuse the tenant's performance, but it was a very discrete, it was a non-monetary performance obligation. It was an obligation to maintain certain levels of insurance, and the level of insurance required by the lease became unavailable. And the court held that that was a force majeure excuse for the tenant's performance. They had to maintain a lesser level of insurance, and this doesn't get them out of paying rent or enable them to terminate a lease or anything like that. It just means that they didn't have to perform the covenant, which the law at the time was preventing them from performing. And if we can go on to the next slide. DC. This is a case, this is a Whole Foods on Wisconsin Avenue, and the tenant was forced to close a few times due to DC orders due to rodents. And when they dug into the issue, they realized that they had to substantially renovate the space to get rid of the rodent problem. And the lease was subject to a covenant that while the tenant could make modifications during the term of the lease, it was a very long-term lease, they could never be closed for more than 60 days. And they started down this path, realized that they couldn't get through the permitting process with the district and make the repairs within 60 days. And the court held, this was a summary judgment, so this was not the ultimate disposition of the case, but the whole court had held that that force majeure could excuse the tenant in this instance from its obligation to remain open, but it did not permit the tenant to not pay rent. And you'll find in leases that generally rent is an independent covenant. You will find the express contract terms say that come hell or high water, you're paying the rent. And even if you're in a dispute with the landlord, you pay the rent and you fight about it later. And to remember that that tenants, even when this is happening right now, are still using space in one way or the other. So there are other solutions to this than necessarily to go to court. Landlords, and as I mentioned earlier, landlords and tenants, nobody's done anything wrong right here, but there has to be a solution. And what I'm finding is that landlords are amenable to making arrangements with tenants that put tenants in a situation to be around in 4 months, to continue leasing space so as to be a tenant for years to come. Now, there's limitations on that because landlords have lenders and the landlords have to pay mortgages. So all this is, the takeaway from this is you should talk to your lender, you should talk to your landlord. There's mentions of leverage, and that works both ways, but I think you want to have a conversation, because I think that everybody understands that we all just have to figure out a way to get through this, and therefore I think people are amenable to negotiated solutions. Other things to look at, as Ben mentioned, is look at business interruption insurance and see if you have any relief there. If there's any way you have rent interruption insurance, whether you're a borrower and therefore a landlord, or whether you're the tenant. And understand that since most leases are long-term, I think it's doubtful that any of this is going to enable anyone to terminate a long-term lease, but you may be able to find some relief from your landlord. And further, it's ever evolving, but there's emergency legislation in many jurisdictions that are protecting tenants and borrowers. Let's see, New York has banking legislation right now that holds that it's a violation of the banking law to not provide certain short-term forbearances right now, given what's going on. There are prohibitions on evicting commercial and residential tenants in New York right now. In DC, practically speaking, you can't evict anyone right now because it's per Emergency Act impossible to issue a summons. So there are solutions to be had if you will talk to the contract parties, and then we will figure out a way to get through this. And now I'm going to turn this over to my partner Ed in New York. Ed?
Thanks very much, Jen, and good afternoon to you all. I won't repeat the basics of the defenses that have been talked about by my learned colleagues in other jurisdictions. They're very similar in New York. The common law doctrines haven't really changed much. They're very applicable and to a variety of jurisdictions in the U.S., and almost all of them follow the restatement or will listed on contracts one way or the other. I will say, though, that what's critically important are the language of any force majeure clauses, as well as the facts of your particular case. So I thought it might be useful to focus on New York in the context of a seminal event that most of us remember well. Many of us were adult and practicing or in a professional situation. Others may have been younger, but it was 9/11. And we've had other important disruptive milestone events, but I'm looking out the window in suburban New York City today, and it's a beautiful day, much like 9/11 was, a Tuesday, almost 20 years ago, which is amazing. But that particular event disrupted many activities, commercial and other activities in the New York area, but also impacted deeply the entire country and really the world, but certainly in the U.S., New York, California, D.C., Virginia were directly impacted by those events. And in New York, there were orders that were put in by the governor at the time and extended that basically greatly curtailed what people could do both individually but also commercially in terms of getting access to various jobs and services and things of that nature. So it may be a useful comparator to what we're going through now. Could we go to the next slide, please? So I think looking at two cases might be helpful. Both involved 9/11 as an intervening event in two different contract settings. One involving a case that was litigated in New York City in Richmond County Civil Court, and one that was actually litigated in Hawaii in federal court. But both involve sort of how courts, when confronted with a major cataclysmic event, try to sort out the commercial interests of the parties afterwards. So let's look at the first case, which is called Bush, just a shorthand version. Bush is a case that involved an individual who had signed up for an expensive safari in Africa. And she signed up for the safari on May 15th, 2001. And the safari was going to start on November 14th, 2001. There was a cancellation policy in the agreements that she signed and a deposit requirement that required cancellation by September 14th. Otherwise, she would lose her deposit, which was about 20% of the full amount of what she was going to be paying. There was no force majeure provision, and 9/11 hit, and she was stuck on Staten Island, couldn't get into Manhattan for several days because of the disruption and the orders that were put in place preventing travel and people going into offices and things of that nature. And telephone service was disrupted. So she was unable to cancel her trip until September 27th, so a couple weeks after. There's no evidence that the phone worked and that she was kind of making this up, and no evidence that the consumer, this person, was prevented from contacting the travel people, the travel agent and the tour operator. So when she demanded the return of her deposit, the tour operator refused to do it, and the consumer sued in her home court. So this is an example to Ben's earlier point about be careful about standing on contract rights in the face of harsh realities, because this was obviously a harsh set of facts for the tour operator to be standing on. Next slide, please. So the court, civil court, so it's a very busy court. It's a lower level court, but this particular judge wrote a very lengthy opinion, and I think did it with the intention of scolding the tour operator for having the temerity to bring the suit in the first place. The court noted that New York City was in a state of virtual lockdown, with travel either forbidden altogether or severely restricted. Precedent is plentiful that contractual performance is excused when unforeseeable government action makes such performance objectively impossible. So here's an example, no force majeure clause, but yet the court is saying, let's look at the reality of the situation. The court actually looked at World War I and World War II situations where, because of intervening events like war, the parties were unable to fulfill their contractual obligations. So perhaps a useful analogy here. The court did note that the governor had issued an executive order tolling limitations periods and periods for filing new lawsuits and other official documents well beyond the time limit for canceling the safari, which here was only a few days. And then went on to note that to even hint that the consumer failed to raise a triable issue of fact by her argument that the doctrine of impossibility excuses her late cancellation of the safari borders on the frivolous. So, again, word to the wise, be really careful about trying to enforce contracts and that have performance obligations, even ones that may have time of the essence obligations within the next several weeks. And the court in that situation also looked to see if there were any hardship that might inure to the travel companies and found none. So that's one example of an impossibility defense basically winning the day in the context of 9/11. Let's look at what happened a few months later in Hawaii, if we look to the next slide. This was a case called Clear Channel, again, a federal district case from Hawaii, where Clear Channel, a big communications company, was going to have a conference in Hawaii. The Clear Channel signed up for this particular conference on November 19th, 2000, and had up to 500 rooms blocked for this big conference. So a lot of money was at stake here. The contract was governed by Hawaii law and had a liquidated damages provision that basically said if cancellation happened at any time 30 days before the group's scheduled arrival, liquidated damages in the amount of 100% of the guest room revenue plus taxes would be due. So even though the conference wasn't supposed to happen until mid-February 2002, the company here, Clear Channel, waited several months before canceling. And it did so because I think it took an overly technical reading of what their force majeure provisions contained, which basically said performance would be excused if various acts, including terrorism or any other emergency beyond the party's control, made it inadvisable, illegal, or impossible to perform their contractual obligations. So Clear Channel, et cetera, basically seized on this inadvisable word, which is very broad, and thought they had a loophole that because of economic situations permitted it to cancel late. So it basically said that, we're having a lot of trouble filling these rooms. They only filled about a third of the rooms, and they wanted to get out of it based on the 9/11 situation that had curtailed resort travel. Next slide, please. Well, the district court, again, in Hawaii, applied Hawaii law as the contract required, looked at the force majeure provision, looked at the late cancellation, and said, while inadvisable, in quotes, performance within the force majeure provision potentially gave the communications companies an out, it did not think that simple economic hardship qualified as inadvisable performance. It said that it had to be viewed, the word inadvisable had to be viewed against the context and in the context of all of these force majeure provisions generally, which, as our colleagues have said earlier, excuse performance not for economic misfortune or even where the economic conditions are a product of some event, but really physical impossibility or practical impossibility. And they did note that over 4 months had passed since 9/11 before the cancellation occurred. So the timing here was very important, I think, in the court's determination that the canceling party sat on their rights for too long. So let's go to the next slide, please. I think a couple takeaways before we wind up and go to questions. There's an old adage, bad facts make for bad law. I think we've all heard that at some point. Well, maybe a twist in this current situation based on some of the courts in their rulings on force majeure provisions is bad facts lead to equitable outcomes. Meaning, as I think everybody has suggested or would agree, courts, when gripped with an event that causes major global upheaval, loss of life, economic misfortune, are going to bend over backwards to split the baby when they can, to do the right thing, to be Solomonic. So if you're going to stand on the exact letter of your agreements, you better just be careful, because you're going to probably be called on the carpet by an angry judge or arbitrator for your inability to try to work something out with the other side. Think about whether, if the roles were reversed and the courts were in different locations, whether that might affect the outcome of these decisions. Probably not, but you never know. It's important what forum you're in. I think it's easier to rule for a Hawaii-based resort if you're a district court in Hawaii, and easier to rule for a consumer if you're the Richmond County Civil Court, if the person is located in Richmond County. So if you have a venue provision, take a look at that venue provision and think about very carefully where you might have to litigate this. And then, again, timing is important. The sooner you can try to clarify your contract rights in the wake of this horrible situation everybody is in, I think the better. And I would think that would include going to a process of negotiation sooner rather than later with your counterparties. Try to get a dialogue started. Hopefully they'll be under guidance to be reasonable as well. Perhaps, as my colleague Ben suggested at one point, mediation might be a perfect solution if the mutual hardships seem actually fairly balanced in the situation. So that's about all I have. Let's go to the next slide, please, and I'll be in a position to turn it back over to Chris O'Brien on the West Coast.
Great. Thanks, Ed, and thanks, everybody. You know, as I'm listening to these presentations and putting on my general counsel, what everybody is, there's a lot of flexibility, these legal doctrines for judges to make based on equity, which is really based on fairness. And one of the common themes is a commercial resolution that works for both parties. Seems like the best solution at the moment, maybe better than trying a litigation solution, which may mean you agree to go into mediation or binding mediation, but some kind of a commercial solution. And we're working through these right now with clients, which might mean forbearance of performance. It might mean suspension of performance for a set period. It might mean pay reductions. These are always going to be handmade solutions depending upon the situation. But it strikes me that we're in a world where the whole web of performance is broken down globally. This isn't a local issue. It doesn't cut across a single industry. And we're really in a different world, and predicting litigation outcomes becomes even more difficult. Having said that, I did want to get, since we have about 5 minutes left, get into some specific real-world questions that I can pose to folks here, and maybe take 30 seconds or a minute to talk about some individual cases that are happening out there. So Ben, let's say there's a supply contract that requires somebody to deliver materials or something else on a regular basis, and because the supply chain's broken down, it just can't be performed. Can you talk about that in the context of California law, which frankly isn't very different than other states' law?
Sure. Yeah, I think in these supply chain situations, you have to look at all the parts of the supply chain. So, for example, if I have contracted with a general contractor to, build a commercial building for me, and because of the lockdown order, the general contractor can't go forward with that, that may be a very good argument for me as the person that's hired the general contractor to not pay the general contractor. But at the same time, further down the supply chain, the building material suppliers may have delivered millions of dollars worth of materials for the purpose of that construction job. Now, who should bear the burden of that? Does that mean that just all falls on the person who delivered the materials not to get paid? I don't think so. I think you have to take a broad view of these situations
and you're going to have to share the pain if you want to look like you're trying to be reasonable. So that's all I would say on that, is that, you know, it's not just a narrow focus, what is the contract language? It's a broad focused, who's being hurt, what can be done to balance out that hurt across all the parties. Let's pass it back to you, Chris.
Yeah, and in the context of an employment agreement, let's say there's an employment agreement for somebody who's a full service, full commission broker or an agent, and the underlying business just isn't happening. There's no revenue coming into the business because of the nature of what's happening. The employee really can still be employed, but they can't actually perform and do what the contract was set forth for them to do. And likewise, the business is having trouble making payroll because no revenue is coming in. Can you talk about that situation, which is happening every day across industries?
Yeah, I mean, this is obviously a world where we all get up in the morning and wonder, you know, what is my job going to look like as this thing progresses? And we're all making accommodations at home, and we're doing all kinds of different things to try to, you know, maintain a semblance of normality in a very abnormal situation. So in terms of written employment agreements, obviously there are specific things that you should all look for within those agreements. In most jurisdictions, certainly in New York, there's a presumption of at-will employment. So unfortunately, I think people are going to get laid off because of the economic crisis in order for the companies to maintain solvency, because if they're paying payroll and they don't have any revenue coming in, it's not going to last long. But if there are specific agreements, usually, again, there are termination for convenience provisions or termination for cause provisions. Usually the for cause termination provisions won't be applicable here, but there are going to be severance obligations that will incur in most written agreements. So take a look at those written agreements. I think the best thing to do is to start having conversations again with all of your employees in various strata. I know that certain employers will need to basically cut pay and reduce compensation and try to maintain the balance sheet as we progress through the next several weeks, in the hope that relief will be coming either from government or in a manner that suggests that the disease is running its course. Too early to tell on that, but I would start contemplating approaching any contractual commitments with an eye towards being flexible, because everybody's in a situation now where they've got to make some adjustments.
Well, we'll leave it there. I see questions coming in on our widget. We'll do our best to answer those offline. And in closing, in addition to thanking the presenters and the staff folks who are behind this, who we're really dependent upon, I wanted to say to you, the folks who are listening, who are our clients, what we've been saying to clients for the last week or two, which is we will get through this, and we'll get through it together. Our firm has been here for over 100 years, and we intend to be here long after COVID-19 is just a sad chapter in their history books. And we're here because of you, and we're here for you. We're a phone call or an email away. All of our contact information is in the slides. If you have issues, if you have questions, contact one of us or contact your Venable partner. People often say in contract negotiations, we want to partner with you. It doesn't sometimes mean that much in the good times. The bad times are here. And it's time for people to look at their partnerships in that light. We mean it. We are here for you, and we will get through this together. So be safe. Take care of your loved ones. Be well. And thank you.